Hi friends, today's second business standard editorial is titled Death and Dignity, and it is a very detailed editorial explaining about the first authorization of passive euthanasia being allowed by the Supreme Court of India after it was legalized in 2011. Now, by permitting passive euthanasia for 31-year-old Mr. Harish Rana, who has been in a vegetative state since 2013, the Supreme Court has drawn a new chapter in India. Since the legalization of passive euthanasia in 2011, Mr. Harish Rana is the first patient to be granted a passive euthanasia in India, 15 years after legalizing passive euthanasia. Now, what is euthanasia? Euthanasia or mercy killing means an intentional process to end a life to relieve extreme suffering. There are two types of euthanasia, passive euthanasia and active euthanasia. Which all countries other than India has laws on passive euthanasia? European countries, Canada, Australia, New Zealand and Japan. What is the difference between passive euthanasia and active euthanasia? In passive euthanasia, a patient is allowed to die by removing a medical treatment. What is a medical treatment? Like ventilators or a breathing pipe, etc., due to which a person is staying alive. Active euthanasia means making a person die by injecting items that causes death. It is illegal in India and it is similar to murder. When was passive euthanasia legalized in India? It was legalized in 2011 in a judgment of Aruna Shanbaug case. Now there are so many cases, not so many, a few cases that is concerned with the passive euthanasia in India. The first one is, as I just mentioned, Aruna Shanbaug case in 2011. So Miss Aruna Shanbaug was a nurse in Maharashtra. Following a brutal rape, she was in a vegetative state for 37 years as of 2011, and the case was filed to let her die through passive euthanasia. In that case judgment, the court legalized passive euthanasia, but ironically, Ms. Aruna Shanbaug was not allowed for passive euthanasia. Why? Because as per rules, the decision to discontinue life support must be taken by parents, spouse, or other close relatives. Since Ms. Aruna had none of these people, in the absence of them, the decision has to be taken by a next friend. The court decided that the next friend as the hospital administration that took care of her for 37 years, and the hospital administration was not willing to let her die. Finally, she died due to pneumonia in 2015 after 42 years in vegetative state. Another significant court ruling is the Common Cause versus Union of India in 2018. It said that Article 21, right to life, means right to live with dignity also. When a person is having an artificially prolonged life, like a person in ventilator, he is just a mere biological existence. Means he is having life, but his life does not have any dignity. And therefore, right to life also means right to not live or right to die. It also said that in a living will, if a person states that he is to be euthanized if he is in a vegetative state, then it is to be respected. But getting this living will was a difficult task. What is a living will? A living will is a legal document outlining your medical treatment preferences if you are incapacitated and unable to communicate. It specifies what life-sustaining measures like ventilators or feeding tubes you do or do not want in terminal illness or permanent vegetative states. Living will ensures your autonomy and dignity by guiding doctors and your family during crises like when you are in a coma or advanced dementia. But getting a legal will in India is a very difficult process. In 2018, that was when the living will was introduced or legalized, it said that the living will of a person has to be have a counter signature by a judicial magistrate first class, submission to a designated local officer, and finally evaluation by a medical board if the executor becomes terminally ill. In 2023, it was changed to a signature by two witnesses attested by a notary or gazetted officer, and it must be handed over to a custodian, and a custodian is someone who is a competent officer of the government. But no Indian state had appointed a custodian except Maharashtra in 2024, that too after filing a PIL. Legal guidelines for euthanasia. Now, how will a decision to euthanasia be taken? The decision has to be taken by a two-tier board. In the first board, there will be doctors treating the patient and two experts with more than 5 years of experience. Once they assess the condition of the patient, they recommend or not recommend to withdraw the medical care, and it goes to the second board. The second board consists of 3 experts nominated by the district chief medical officer. They review the case and make a decision within 48 hours. In 2018 Common Cause versus Union of India, the Supreme Court said to remove medical treatments like ventilator or mechanical breathing assistance for passive euthanasia. But Mr. Harish Rana had neither of these. He only had a feeding tube, and a feeding tube is not a medical treatment. Therefore, if it was removed, it becomes active euthanasia. Then in 2019, Supreme Court held that feeding tube or clinically administered nutrition is also a medical treatment, and this led to clearing the final blockade in the path of Mr. Harish Rana's passive euthanasia. In summary, there is no glory in letting a person continue with his life once the decision to euthanize has been arrived at. The bureaucratic steps after that decision must be made simpler and robust. Thank you.